You've already heard all of the instructions during the guilt phase and a brief instruction in question during the firearms phase. These are brief instructions, but complete instructions on how you make your determination in this phase of the case. The defendant has entered a plea of not guilty by reason of insanity to these charges. Under the laws of the state of New Hampshire, a person who is insane at the time he acts is not criminally responsible for his conduct. The defendant, as you know, has raised the defense of insanity. Insanity is an affirmative defense. This means that the defendant has the burden of proving by clear and convincing evidence that he was insane at the time of these crimes. Clear and convincing evidence is evidence indicating that the thing to be proved is highly probable or reasonably certain. In this case, the defendant must prove that it is highly probable or reasonably certain that he was insane at the time of the criminal acts on October 12th of 2019. The defense of insanity is essentially a claim that the defendant is not responsible for the criminal acts he committed on October 12, 2019. By raising the defense of insanity, the defendant says that he suffered from a mental illness or disease, also referred to as a mental defect or mental disorder, which made him not responsible for his actions at the time he acted on October 12, 2019. Put another way, a defendant asserting an insanity defense must establish that he suffered from a mental illness and that his criminal acts were a product of that illness. These are questions of fact for you to consider as a jury. There is no legal standard to determine whether or not the defendant suffered from a mental illness or disease which rendered him not responsible for his actions at the time he acted. Whether or not such mental illness or disease existed on October 12, 2019 is for you to decide. If such illness or disease existed at that time, whether or not the defendant suffered from one of them at the time he acted is for you to decide. There is no simple test in deciding whether the defendant was insane at the time of the crimes. Insanity is merely a question of fact to be decided by you based on all of the evidence as submitted in this case. The testimony of expert psychologists may be considered by you, but the testimony of lay people may be considered as well. And the ultimate question of insanity is for you, the jury, and not for psychological experts. In deciding whether the defendant was insane, you may consider any evidence of insanity, whether the defendant was suffering from delusions or hallucinations, whether the defendant knew the difference between right and wrong, whether the defendant acted impulsively or acted with cunning and planning in executing these crimes. You may consider other symptoms, such as whether the defendant could recognize friends or manage his own affairs. None of these, however, is a test for insanity, but you may consider all of these things. The basic question you must decide is whether the defendant should be held responsible for his acts as a criminal, or whether he should be held not responsible as a criminal for his acts and treated as a person suffering from a mental illness or disease at the time he committed these offenses. If you reject the defense of insanity, the defendant will receive sentences for his crimes. However, the possible punishment of the defendant should not influence your decision. The duty of imposing sentence, as I told you before, is for me, the judge. If he is found not guilty by reason of insanity, I will conduct a hearing on the defendant's dangerousness not later than 40 days following your verdict. If the defendant is found to be dangerous to go at large, he will be committed to the secure psychiatric unit at the New Hampshire State Prison. The commitment could be for as long as the rest of the defendant's life. However, the defendant can be released at any time he can prove he is no longer dangerous. In any event, the defendant, if he is committed, he is entitled to a hearing every 5 years at which the state must prove, by clear and convincing evidence, that the defendant is still dangerous. You are not to consider the issue of the defendant's dangerousness. Again, this is a matter for the judge. The sole issues for you to determine are whether the defendant was suffering from a mental disease or illness when he committed the criminal acts on October 12, 2019, and if so, whether these acts were a product of his mental disease or illness. The final instruction I'll give you is one you've heard before, but you need to hear it in this phase also. It relates to expert testimony. You heard the testimony of 3 expert witnesses in this case: Dr. Stephanie Tabashnik, Dr. Eric Mark, and Dr. Shannon Bader. An expert is someone who has some specialized knowledge, such as scientific or technical knowledge, that qualifies the expert to give an opinion as to matters that are not common knowledge. The opinion of an expert may assist you in understanding the evidence or in deciding the facts of this case. You are not bound by the opinion of an expert. You are free to ignore the expert's opinion if you find that the reasons given in support of the opinion are not sound, or if you find that other evidence outweighs the opinion. Those are my instructions to you. I will also give you another verdict form. It just has one question on it. The question is this: do you find by clear and convincing evidence that the defendant was insane at the time he committed the criminal acts on October 12, 2019? There are 2 answers. Yes, which would mean he was insane. No, which means you would find that he did not meet his burden of proving that he was insane. Very simple question. You will receive the verdict form and the instructions. We will return all of the exhibits to you for your consideration. We will get the laptop back in there, the clean laptop for you to use. So you are now free to discuss this phase of the case, specifically the insanity defense, and to deliberate until you reach unanimous agreement on that question I have asked you. Again, I ask you to listen carefully to each other, to make a decision based on the evidence and the law, and to do it in a way that is understanding that you are to exercise your good conscience and honesty in reaching this verdict in a unanimous manner. You have all my prior instructions, and you have this special instruction on insanity for your consideration. Obviously, if you have to look at the prior instructions to consider the evidence, you are not in any way looking at the charged offenses or the elements. You've already reached your verdicts on those 7 charges. It's the 6 verdicts of guilty that you are considering this insanity defense on. Thank you. I wish you well in your deliberations. Again, if you have any legal questions, you know how to do that. Your foreperson remains your foreperson, and she can submit the question to me, sign it, date it, and we will answer it after the lawyers and Mr. Holloway and I talk. Enjoy your lunch. You got another lunch coming to you during this deliberation. You are released to deliberate. Thank you very much.